Mr Chairman, I recognise the Honourable Member Charles Chevelle.
Thank you very much, Mr Chair. Mr Chair, this part of the amendment bill is a new part. It's a very small part and it's introduced in order to make amendments to the Smoke-Free Environments Act that are consequential on the other amendments in the Minister's supplementary order paper that the committee has just agreed to. So when we deal with this part, we need to understand that what we're doing is repealing in the Smoke-Free Environments Act the definition of prison and also changing the definition of workplace because of the exclusions that we've just agreed to as a committee. So what I want to do, I hope with the indulgence of the committee, is just ask the Minister to consider the way in which those previous amendments have been put together. Because I think from her discussion with me and on a reading of the legislation, the debate hasn't been entirely fair to her. I think she has tried to get the officials to come up with a solution that doesn't involve retrospectivity, or at least that limits the extent to which retrospective legislation is to be applied in this situation. I think I'm right, and the Minister's nodding. Accepting that she has sought to try to fix up the mess in as constitutionally appropriate a way as she can, I still wonder whether the wording of the legislation is as good as it could be. And I said before, I acknowledge that the Minister had consulted me about it, and I put that on record again. This debate's the first opportunity I've had to respond, and I'm trying to do that in good faith. I said before that I was concerned that the mechanism that the substantive legislation uses is to restore the legality of the ban, to declare the regulations and the rules to be treated as if they're part of the Act from the date of the tabling of the supplementary order paper. And the way that the Minister's attempting to protect the Crown's liability is by the provision in the enactment that no proceedings may be brought against the Crown questioning the validity of those rules and regulations. Well, I expressed some concerns about that provision earlier, and it's just occurred to me there's another category of proceeding that we might not be dealing with effectively through this legislation. And I wonder if the Minister would consider this situation. Presumably under the ban that was implemented administratively, for want of a better way to describe it, there were situations where a prisoner was subject to disciplinary proceedings because he or she possessed tobacco which was declared to be contraband and was found to possess it and was then subject to, as I say, a disciplinary procedure. I wonder what the position would be under this amendment if a prisoner now took proceedings to question the validity of the outcome of that sort of disciplinary proceeding. Because it seems to me that they would not, by those proceedings themselves, necessarily be questioning the validity of the rules or regulations. They'd be questioning the validity of a penalty imposed on them by legislation or rules that have subsequently been found to be ineffective. So it wouldn't be questioning the disciplinary outcome wouldn't necessarily be questioning the validity of the rules and regulations, or at least not only questioning the validity of the rules and regulations. And I am genuinely keen to see whether the Minister would confer with the officials and just perhaps provide some comfort to the committee on that point. And perhaps while that's being done, they might want to consider the other issues that were raised earlier about, for example, a complaint to the Regulations Review Committee. Would that be a proceeding or would it be something else? and should we be concerned about that? And what about independent proceedings based on claims under the New Zealand Bill of Rights Act for damages or judicial review? So if the Minister would consider those issues, I think it would be very helpful.
I call the honourable member